The news is just one court case after another until your brain automatically starts playing Love Shack as soon as it hears the words v. Trump. Fortunately for you, I am here to chomp out the most important stories and keep you up to date with minimal interruptions from the best new wave hits of 1989. Happy Thursday, everybody. I'm Brian, and this is the Morning Report on the federal courts for August 28th, 2025. Guys, I have survived almost an entire month making this show every single morning, so please do me a favor, double tap your screen, like, comment the case you are following the closest, and try to watch through at least the intro so this will hit the FYP. And I could use a bit of support right now, so if you'd like to help out, check out my link tree in my profile or my new mugs and shirts at brianodc.com. All right, grab your coffee, let's get to the news. All citizens of Utah should be outraged at their activist judiciary, which wants to take away our congressional advantage and will do everything possible to do so. This was shared in a tweet from the president after a Utah judge who was appointed by a Republican governor overturned the new Utah electoral maps on Monday because they failed to comply with a voter-approved ballot measure from 2018 requiring districts to be drawn by an independent commission. Despite the 7-year-old law, the Utah legislature decided to redraw the maps to make the state more favorable to Republicans. The judge said, the legislature intentionally stripped away all of Proposition's core redistricting standards and procedures that were mandatory and binding on it. To permit the 2021 congressional plan to remain in place would reward the very constitutional violation this court has already identified and would nullify the people's 2018 redistricting reform. The court has ordered lawmakers to redraw the congressional districts in accordance with Prop 4 by September 24th. And if the new map doesn't meet the standards, then the plaintiff and other groups may submit their own maps for the court to consider. Next, we are going to talk about U.S. v. Illinois. Now, I mentioned this case about a month ago because there's another case that's almost identical, which is U.S. v. New York. If you haven't noticed, 95% or more of our cases are somebody v. Trump or somebody v. RFK. The feds are almost always second, and that's because they're the ones getting sued a lot these days. So the first name is always the one suing, the second name is getting sued, just FYI. So this is U.S. v. Illinois and U.S. v. New York. So in both of these cases, the feds are suing these states because there are state laws in place that protect non-citizens, and the federal government is trying to get those laws invalidated. And the Illinois case has been dismissed by the court, so the federal government lost. But by now, we've seen the Trump administration doesn't lose. They just appeal and appeal and appeal until people get tired. And in this case, they didn't even have to. The judge dismissed the case back in July, but said in the memorandum that the case was dismissed without prejudice and gave the federal government a chance to file an amended complaint to make corrections. But they never did. Now, we've been talking about staffing issues at the DOJ. I don't know if that was a factor, but on Tuesday, the judge filed a new order and said basically, he's heard crickets from the government, and the time window for their amendment just closed a few days ago. So the judge has changed the ruling to a dismissal with prejudice, which means it's done, gone. Now, whenever the U.S. is a party to a case, the deadline to file an appeal goes from 30 days to 60 days. I think it's Rule 4, something in the Federal Rules of Civil Procedure. But when you appeal, you're appealing a judge's reason for closing the case. And here there's nothing really to appeal because the decision that he gave them a chance to refile. He never said no. So they can appeal the reason he didn't like their first argument, or they can appeal his reasons for closing the case after 30 days. But they sort of lost the ability to respond correctly with a second argument, I think permanently. More importantly, if they try to appeal this and lose, it'll become precedent and could kill their identical case in New York as well. So this one might actually be dead in the water. Never say never, but I'm really happy to see one of these cases potentially closing for good. Maybe? All right, now we're going to look at the case of Alawieh v. Tweedie. I thought I saw a putty tat. Okay, this is a case of a surgeon and specialist in kidney transplants who taught at Brown University and was on her way back home from visiting family out of the country to Boston, where she lived and worked on an H-1B visa. When she arrived at the airport, she was detained by Border Control, her cell phone was confiscated, and she was immediately deported. I mean, what do we need kidney transplant surgery professors at Ivy League med schools for anyway? Good riddance. Well, anyway, yesterday, her attorneys filed a rather interesting thing with the court I wanted to share. I don't know if it'll work, but it's interesting. The general idea is that the people who handled Dr. Alawieh's case at Logan Airport were low-level employees, not appointed officers of the United States under the Constitutional Appointment Clause. They swore her in, they took statements, they basically performed an entire court case with no possibility of appeal and then decided that case and executed the outcome. And Dr. Alawieh says, under that level of control, those employees should have been subject to the Appointments Clause like all officers of the United States. And she cites a recent Supreme Court case decision, Kennedy v. Braidwood, from earlier this summer, which said what matters in determining if a given role has officer status is, quote, the extent of power an individual wields in carrying out his assigned functions. By that standard, these guys had a lot of power, and they should probably qualify as officers. And if they were officers, then her deportation was never properly issued in the first place because no one who issued it had the authority to do so. It's an interesting theory. It would require either every airport to have appointed officers, or maybe more time to be taken in processing these cases. Anyway, it's a unique theory. I am guessing we will see this one at the Supreme Court. Okay, last stop, everybody. The judge in Friends of the Everglades v. Noem issued an order earlier this week seriously restricting the growth of the facility and requiring that they remove fencing that is restricting access to the land by native tribes. And as we've come to expect, the government responded with an immediate appeal and a motion for stay pending appeal. And the judge responded yesterday with a rather flippant 8-page denial, letting them know that a stay was unwarranted. The judge cited specific evidence of diesel dripping into wetlands and the lack of protective barriers that should have been installed, and the immediate danger posed to the surrounding area by these kinds of oversights. She also cited the fact that all of the government's arguments in favor of their motion involved immigration policy, which was kind of irrelevant to the question at hand. So the stay is denied, and normally I'd say we'd see the government's appeal of that denial any minute. But word is the state of Florida intends to dismantle the facility almost immediately after receiving the judge's ruling. This means that the facility, which cost more than $250 million to build and will cost another, they said, at least $20 to $30 million to break down, all paid for using FEMA funds, will have operated for a total of about 60 days. So that was a fun exercise, and I'm sure Florida won't miss that FEMA money at all during hurricane season. All right, that is your Thursday morning report on the past day in federal courts. Again, if you can leave a comment or get this out there, I would appreciate it. Otherwise, keep watching, everybody, and I'll keep going. Thanks a lot. Have a great Thursday, and I will see you tomorrow for the Aloha Friday morning report. Bye, everybody.